Justice Gorsuch? Justice Kavanaugh?
In response to a lot of the questions, you've made the point that bump stocks were not around as of 1934, and that's a good point for you. But what evidence is there, if any, that as of 1934, the ordinary understanding of the phrase function of the trigger referred to the mechanics of the gun rather than the shooter's motion?
Well, it had to, and the evidence that we can see is the evidence the Solicitor General points out about the fact that there were push triggers in existence at that time. And that function of the trigger, even though you can find legislative history where there seem to be people who think function of the trigger means the same thing as pull of the trigger, those phrases cannot be equated for that very reason.
I guess I'm asking the opposite. Was there any evidence that someone was drawing that distinction?
Drawing the distinction between push and pull?
No, the distinction between that function of the trigger meant something different.
I'm not aware of that in the legislative history. But
are you aware of that anywhere in kind of communication at the time?
Not at the time, no, because the communication, as we can see from the record, was rather sloppy. People were using pull of the trigger as a phrase that they thought was synonymous with function of the trigger. And that obviously is not the case.
Okay, so no one that was saying, oh, function of the trigger, that's a different phrase than pull or push, and therefore it means something different. Are you aware of anyone who said that anywhere in America at the time?
I'm not aware of that, but as a textualist, I don't find that concerning because...
Well, as a textualist, you have to think about the phrase, not just each word in the phrase.
That's right. That's right. And when we look at the phrase function of the trigger, as I was saying earlier, and Justice Gorsuch made this point in some of his earlier questioning, function of the trigger. And trigger is, we talked about this before, trigger has to be the subject of function. It can't be the object.
Right. And now, so the follow-on question is just focus on the phrase, and I'm just making the point, I don't think anyone said this at the time, which doesn't defeat your argument. I'm not suggesting it defeats your argument, but it would obviously help your argument if people were drawing that distinction.
It certainly would help, but the phrase, given the way it's written right now, and the impossibility textually of trying to make trigger into an object of the verb function.
And then no one was drawing the distinction. Why would Congress have drawn that distinction? Your big point, I think, we got to look at 1934. We got to look at what Congress wrote. Why would Congress have drawn that distinction in 1934?
Because they wanted to get the fully automatic weapons that had the push triggers. And if you use pull of the trigger, you're not going to reach those devices. So they had to say function of the trigger to make sure we encompass those forms of weaponry, as well as the conventional fully automatic
cover
weapons.
Push and pull.
Push and pull, exactly.
And how should it be defined now, in your view? You may have just answered this, to cover bump stocks. In other words, if tomorrow Congress said, Mr. Mitchell, how should we write the statute to cover bump stocks since function of the trigger, in your view, doesn't do it?
Well, I'd have to ask them what else do you want to encompass besides bump stocks. If they want to make it specific.
Just bump stocks.
Well, then I would...
give me a sentence that you think would cover bump stocks.
I would provide a statutory definition of bump stock that tracks as closely as possible the non-mechanical devices that Mr. Cargill has. And I certainly wouldn't say single function
great statutory language. Yeah. You got anything better than that?
I think you could say any device, and this may be a little too broad, but you could say any device that is used to accelerate the rate of fire from a semi-automatic weapon. That would probably capture, that would certainly capture bump stocks. It might capture some other things, but those other things would be similar enough to bump stocks that Congress would probably want to ban them as well.
Yeah, back in the 30s, some of the state statutes did that, I guess, at the time. Okay. Last question. You haven't made a Second Amendment or constitutional avoidance argument. In your view, are bump stocks covered by the Second Amendment, protected by the Second Amendment?
We didn't argue that because courts are generally loath to decide constitutional questions when there's an easy statutory off-ramp.
You didn't throw it in as constitutional avoidance, and I imagine that was a considered choice. I'm curious what was behind that choice.
There's nothing that prevents this court from invoking the constitutional avoidance canon on the Second Amendment issue, because there is a question, at least, whether this falls within the dangerous and unusual weapons carve-out in Heller. We don't have a position on that question because we didn't brief it, and also dangerous and unusual weapons is vague enough that it's just not clear to us what the answer would be.
Thank you.
Thank you.
Justice Barrett.